Hey guys, welcome back to my channel. In the previous video, we discussed about the Indian Evidence Act introduction, applicability, as well as certain expressions which are mentioned in section 3 of the Act. Today, we are going to discuss about the relevancy of facts. What are facts? What are relevant facts? We all have discussed in the previous video. So today we are going to discuss them in detail. As I've mentioned before, relevancy of facts is described from section 6 to section 55. But before that, it is important to know what section 5 says. Let me ask you one thing. In every civil proceedings or in criminal proceeding, what kind of evidence is to be given? The answer of this question lies in section 5. So let's begin with section 5. Evidence may be given of facts in issue and of relevant fact. I'm reading it from the Bare Act. What does this section says? It says that in every civil suit or in every criminal proceedings, evidence is to be given of every fact, which is, I have divided this section into several points for you to understand it better. First is facts which are in existence. That means this section applies to facts which are in existence. First point. Second point, facts which are not in existence. Third, facts in issue. And fourth, relevant facts. Now, what is a fact in existence? That means those things that have actually happened are the facts in existence. Things that have not happened are facts non-existent. Facts in issue. I told you earlier also, facts in issue are those facts which are asserted by one party but are denied by another party. Let me explain you with an example. Like in the trial of where A murdered B, in this trial, A gave poison to B. B died as a result of such poison. And A had an intention of murdering B. So all these three things are the facts in issue. Then fourth is relevant facts. Relevant facts explained from section 6 to 55. Now we are going to discuss each section separately. Section 6. Relevancy of facts forming part of same transaction. What does this section say? Facts which though not an issue. Facts which though not an issue but are so connected with the fact and issue so as to form part of the same transaction. What does this say? This says in every incident there are certain facts which are an issue, but there are other facts which are though not related to the incidents but are connected with those facts and issue. Therefore, those facts are also relevant, whether these occurred at the same time or at different places. The principle of this section says whenever any transaction is a fact and issue, then evidence is to be given of every fact, of each and every fact which forms the part of same transaction. Here we are talking about transaction. What actually is this transaction? See, transaction is described as a physical act or series of physical act along with the words accompanying such acts. Therefore, physical act plus words accompanying those acts is equal to a single transaction. And this section is actually based on a Latin phrase, res geste. Yes, res geste is a Latin phrase which in English it means things said or done in a transaction. So this section is based on this Latin phrase. So the things said or done in the course of transaction that are connected with the fact and issue are all relevant facts. Let me explain you with an example. A murdered B by beating him. So whatever was said or done by the bystanders are those who are the persons present at the time of the incident or who have just witnessed that incident. Whatever was said or done by the bystanders during the incident before the incident, immediately before the incident, immediately after the incident. Whatever was said or done by A, that means accused, during the incident, at the time, immediately before the incident, or immediately after the incident. Then third, whatever is said or done by B, deceased, during the incident or immediately before the incident. In all these things, these facts are relevant facts according to section 6 of the Act. Now, before proceeding to the next section, you must be thinking, how do we get to know whether a particular fact forms a part of same transaction or not? Well, it is important to understand two facts are said to be part of same transaction if those facts have happened during the incident, immediately before the incident, or immediately after the incident. Next come to section 7. Section 7 mentions about those facts which are the occasion, cause or effects of facts in issue. So this section is divided into several points, like facts which constitute first occasion, second cause, third effect, fourth opportunity, and fifth state of things. We'll deal with all these 5 points one by one. According to section 7, all those facts are relevant. All those facts are relevant which, first point, constitute the occasion of the act. Occasion means circumstances under which that act had happened. Example, there is a murder of a young girl in her house. So in this case, very fact that she was alone in the house before the incident or say during the incident is itself sufficient to say this was the occasion of the incident. Second point, what we said? Cause. Cause implies why a particular thing has happened or why it was done. This helps the court to connect the person with the act, as the act must have been happened or done by a person who had the cause for doing that act. Third point is effect. Effect means outcome of the act. Every act leaves behind certain effect, and this effect helps to identify the nature of the act or record the happening of the act. In the same example as I quoted before regarding the murder of a young girl in her house, after the murder of the girl in her house, any footprints that have been left behind or any finger impressions that have been there at the crime spot. So these finger impressions, these footprints, all the facts which show these two things are relevant fact according to section 7, and these constitute the effect of that act. Fourth is opportunity. Opportunity means circumstances under which such act has happened or circumstances which provide the opportunity for the happening of such act. This shows that act must have been done by a person who had the circumstance of doing that act or who has the opportunity of doing that act. Fifth point is state of things. Any fact which constitute or which reflects the state of things under which the main or the principal act had happened, this is relevant. And the state of things include relation between the parties, as well as in a case of murder or in a case of a death of a person, any illness that he might be having immediately before his death, or any habits or nature of him. Next come to another section, section 8. Facts which show motive, preparation and conduct of the parties are relevant. So this section lays down three things: motive, preparation and conduct. Section 8 provides the relevancy of three principal facts: motive, preparation and conduct. First we'll deal with motive. Motive is a power which impels or say compels one to do something. It is the inner inducement to do such act. Motive itself is not a crime. Yes, guys, motive itself is not a crime, but if the crime has happened, then the motive from which this crime has happened, that comes into picture, and then motive becomes very important in order to determine such case. Motive helps the court to connect the accused with the act. Second is preparation. Act of preparation are also relevant as to how the person has committed the act or what all preparations he did in order to do such offense. Like act of purchasing a pistol in order to shoot down a person. This is preparation. Mere purchasing a pistol is not a crime. As I said, mere motive or say mere preparation is not a crime, but if an offense has happened in pursuance of such preparation, then such preparation also becomes relevant. There are two exceptions actually for this. Preparation, as a general rule, preparation is not an offense, but according to Indian Penal Code, preparation of dacoity as well as preparation of waging war against the state, apart from these two things, every preparation is not a crime. But in these two things, preparation itself becomes a crime. Third point is conduct. Conduct of party is very important in order to determine a case. Conduct of which party is important? The question is, conduct of which party is important? In every civil suit, conduct of both the parties, that means plaintiff as well as defendant and their agents. Yes, conduct of parties and their agents is also important. In every criminal proceedings, conduct of accused is important and conduct of injured party is also important. Please note, conduct means statements as well as acts. Mere statements do not constitute any conduct. Mere act do not constitute any conduct. Every statement coupled with act constitute the conduct. So that's it for today, guys. I hope you have liked my video. Please subscribe my channel and please hit the bell icon. I tell you why subscribing is important, because if you do not subscribe the channel, then you may be missing certain important videos, because I'll be making videos of the entire Evidence Act in sequence as it is. So if you do not subscribe, then you may miss certain videos, you may miss certain important topics that I'm going to discuss. So that's the reason. Please subscribe and I'll keep on making such kind of videos. Thank you. Bye-bye.